The order date is 29th
Yes.
February.
My lord, may I be permitted item number 1, my lord? Pray for leave because certain subsequent events have taken place, my lord. The officers of after the arrest was made
was not
case
included in the list,
registered, my
but
lord.
now it is included in the supplementary list.
My lord, I was
Subject to
informed by my lord's
convenience,
officer. I was informed
subject
by
to
my
your
lord's officers in the morning, my
additional
lord,
Solicitor General.
regarding this.
If you want, you can make submissions on those appeals also.
My lord, my lord, if my lord fixes it up, my lord, because this affirming of this application will take not half an hour, my lord. So if my lord is so deemed fit and proper, my lord, can this take it up at 12 minutes?
Those two matters are concerned.
And Advocate General,
There is a clear apprehension in the last occasion that they're trying to dilute as they have not only there were so many FIRs, they were arrested specifically in these two FIRs, and they have taken remand, which is contrary to the stay orders granted in two matters, 8 and 9.
Suppose there is a stay of investigation. Arrest was permitted to be done because misreading the state raised saying that there is a stay of arrest. There has not been any stay of arrest. That has been clarified. Order granted in your very appeal.
Right.
Yes, my lord.
But we'll make submissions made on that aspect. If we are wrong, then we'll rectify ourselves.
No, then keep your hands off at least till the matter is heard.
Yes,
Because it's
not as simple as
if investigation is stayed, my lord,
Sir,
then my
one
lord,
at a
they should
time,
put
Mr.
him in
DSG.
judicial custody. Then, my lord, they should put him in judicial custody because
my lord,
they
no,
are
no,
wasting the police custody days without
No, no,
investing,
Mr.
and we
Trivedi,
have
just wait
limited
a
numbers
minute.
of police custody days, my lord, and
Mr.
we
Trivedi,
need
let
his
me make-
custodial interrogation. Even if it is transferred to the CBI,
has been
lordship,
filed, my lord, I
CBI also
request
needs
your honorable, this honorable court to place it before your lordships. Why? Is because of the fact that you all argue for 1 minute. It is my custody which has been taken. Now, once my custody has been taken, I am not given an audience. A. B is that they are paying for me being arrested, and then there'll be an investigational stay. So why should I be in custody? Now, these points of law have to be addressed.
More than
and I have to
41
be made a
cases.
necessary-
Therefore, the issue is your lordship wanted us to give the details of the CBI.
No, I'm trying to
address,
understand
whether
something,
the matter-
that while my anticipatory bail is pending, and it is said by ED before the lower court that only 4 Indian penal code offences are pending, that becomes 41 in my absence before this honorable court without me being heard. I think I have a right to defend.
I am not being permitted to court, my lords. I'm sorry to say by this act. Number one, my lords, there are two types of there are which was supposed to be 307. The learned AG agreed in the hearing before the learned single judge that 307 is to be added. Despite that, section 307 has not been, and they were in this particular case, despite there being a stay,
supplementary
they're going on with
there
it.
we can make it clear now the accused who is now in police custody, in both these appeals, the investigation has been stayed even at the instance of the state. So therefore, the investigation cannot be on behalf of the enforcement directorate wants to file a supplementary on the learned advocate appearing for the accused.
But there may make two submissions, my lord. Number one, my lord, our right to custody of this accused. If police custody, CBI custody should, it is without prejudice, we have a right to take him into custody. That right should not be defeated. That is one thing, my lord. Secondly, my lord, as far as the accused is concerned, his right to be heard in a transfer application is unheard of. Any prayer for transfer of investigation.
No. He wants to be heard in this suo motu proceedings. The learned advocate was submission made that there is an impression created as if this court has granted a stay of arrest. More than once, that has been clarified.
The purpose is
Thereafter,
to
he has
defeat
been
the
picked up.
investigation.
One second, sir. One second. Learned Advocate General,
Yes, my
if there is a stay of investigation,
Yes,
how to hold them in police custody?
Yes. Yes, sir. That is the moot question, which requires to
It is not held in police custody during the first 15 days of arrest. Just 15 days of custody. Those 15 days will click and go away. So the police custody will never be obtained.
Therefore, if according to you, there is a stay of investigation, then nothing can be done. How police can get custody? He should be being given judicial custody.
Anupam Kulkarni's case, the judicial Supreme Court said first 15 days only you can get police remand. Thereafter you can't get. So its period has started clicking. It is defeating the.
That's true, sir. That's true. Neither ED nor CBI were able to arrest
because
him.
the court initially ordered joint custody, against which we were agreed, and we said we want exclusive custody. That matter was being decided. Now that I will not get custody because 15 days are over.
Right to be heard when I'm in custody. Is that what the?
No,
Yes, not in
Yes,
the
sir.
matter of transfer, not in the matter of transfer. Settled.
Very well. I'll address on that, and I'll also
Sir,
understand.
you are not a party. Sir, one second. the accused is not a party in WPA memorandum. The order passed, the impugned order passed in the writ
PMLA
petition.
investigation,
In the impugned
when
order,
they
the
went to
appeal,
search, in that case, they were assaulted. So he said, now after assault, we said that because of the pressure, that those cases must be investigation. Next, my lords, the court said, yes, you are. The
Yes.
learned age made a statement before them. Any interference by the state police would lead to, my lord, improper bias investigation.
Number two,
investigation.
as rightly pointed out by the learned Additional Solicitor General, Mr. Raju, that is under the PMLA Act initiated by this ED. And ED has
while the raid
no
was going on,
jurisdiction
or
to go
when
into
they were trying
IPC
to
and
enter
other
into that
provisions.
premises, which was locked. Milord, the local villagers came over there, Milord, and Milord started Milord assaulting the ED officers. Mr. Raju had an uninterrupted right of hearing. And please extend that courtesy to others also. Milord, the
Yes,
local
yes.
people assaulting the ED
Therefore, Milord,
officials, Milord, 3 cases were started. Nazat Police Station, case number 7, case number 8, and case number 9.
And that is also
Now,
found, my
these
lords,
three-
in para 15 of the impugned order, my lords. Part of investigation. Now they're trying to find out a sort of a loophole in the order and trying to justify an order which
While
is
he started
contemptuous in nature.
contacting someone, we
Now,
do not
as far
know.
as the-
But the tower location showed that he was in that particular house. Now, after that, according to our FIR, 800 to 1,000 people gathered within 15 minutes. The court is desirous of looking into the case diaries and original 2 documents, being FIR number 7 and FIR number 8.
There is
dated
no
registered by the
interpolation in the
Investigation
date or time. If your lordship requires me, I can
And
explain
this
it
is
here
appearing
and now.
before your lordship.
Not recorded. But then.
Now, my lord, I have here also I submit on instruction that in the event if your lordships are so pleased to transfer
All
the
right, sir, judgment
investigation.
reserved. I think we'll stop with this, sir. Otherwise, everybody wants early judgment to be delivered.
Yes, Lordship. Yes,
We'll stop with this.
yes, Lordship.
We are grateful, Milord.
In the result, MAT number 169 of 2024 and MAT number 191 of 2024 are allowed, and the order passed by the learned single bench constituting the special investigating team is set aside, and the writ petition filed by the Enforcement Directorate in WPA 802 of 2024 is allowed, and the cases in FIR number 8 of 2024 on the file of the Nazat Police Station and FIR number 18 of 2024 on the file of the Bongon Police Station shall forthwith be transferred to the Central Bureau of Investigation. The custody of the accused Sheikh Shahjahan shall also forthwith be handed over to CBI. This direction shall be implemented by 4:30 p.m. today, 5th March 2024. No cost connected applications disposed of.
My lord, my lord, there is Nazat Police Station FIR number 9 also, which was lodged by 8 and 9. My lord, the order
Milord, I appeal, Milord, for the alleged contemners. Now, Milord, we have moved the Honorable Supreme Court against the order. Yesterday, the matter was mentioned before the bench, which is.
What is the order? I am not aware of.
my lord,
Let us have the facts.
Right.
I am not aware.
My lord, may I be permitted to state the facts, my lords?
Yes.
Point out, my lord, the incident happened in this manner. The ED was investigating pursuant to an FIR scam, and they went to search the house of the main accused, that is Shahjahan. And when they went there, along with the CRPF team, there were 3 officers badly were injured. Was not opened. 1 was seriously. Therefore, we gave
us
an
hear the
application to file a complaint.
Before
to
that,
the
kindly
police.
hear me. I am appealing for CBI, who was directed to take custody of the accused and also to hand over the documents. Some documents are to be brought to your lordship notice. Now, firstly, my lord, your lordships have seen the operative part of the order at page 41. The next part is page 45.
46 or 45.
45 I have read out.
Yes.
Now, this is the concluding part is page 49. However, it is brought to your kind notice that the undersigned received letter written by another officer in charge of the police station, page 53. Deal disposal the same of the SLP. Now
The
comes the
police
moot
custody
question
can be granted
whether-
only in the initial 15 days. Chunk of the period is over and the custody, we will not be able to obtain custody and proper investigation. You cannot, it's like a self-goal. You cannot just say that I am granting stay to
The
myself.
most
That-
fundamental principles, there is no difficulty in this regard.
No, only
Yes,
one more
let us-
point. One more point.
What
guys.
more?
One more. Yes.
But today, my lord, the custody becomes illegal. Today, the custody of the police order of this honorable court. So that illegal custody has to be
Known
rectified,
details.
and the only
And Milord, with
rectification
this
is
an SOP, I am told. But as per the SOP,
And
Milord,
the-
we
and
had
the court
done
has
whatever
said
was
that
required
I'm
to
not
be
going
done.
to list the
Now
matter
today,
on an
Milord,
urgent
when the-
basis. It will come in a usual course.
And
And
no
what
stay was
this is
granted
what
on
their
oral
version
basis.
is. You are saying that yes, it was entertained to move it, to file it, to move before him. He directed the matter to be placed before the Honorable CJI.
Yes,
All these things
Yeah, I was
appears to
present in
be
the second
a
court,
bit
my lord, virtually when the mentioning was
contradictory,
made.
not
The court, the mentioning was, it was said that the matter is coming up before the
Number one, Milord, I have a right to prefer an SLP. I am pursuing that right. Number one. Number two is, Milord, the shortest possible or post this matter as the first item tomorrow, so that Milord, what development takes place today, Milord, we can.
yes.
My lords, may kindly have a look. What is this request, my lord? The request of the learned AG is that keep the matter tomorrow because my matter is going to be listed and remanded on 29th. That is on an 15 days. The court has granted him 10 days remand. The court may not grant further remand. So
For
during
CBI
these 10
custody
days,
by
we
the
have to
division bench.
take custody and we have to.
So
examine
there's
and
no
we have to
question of
find
an argument that what we are doing since 29.
And there's one more thing, before passing this order, the court said even CBI can arrest. That order has not been
Initiate a
protested
suo
against.
motu
Right,
proceeding for
right.
that.
No doubt about that. No
Contempt
doubt about that.
proceedings only is an informant.
Right.
We have to go. Whether the
Yes.
orders have been flouted, orders have been violated. These are the basic
That
things. the
suo
court
motu
has to
cognizance
consider.
can be taken in a criminal
So-
contempt. The letters written pursuant to the Honorable Division Bench order presided over by the Premier High Court Chief
Learned
Justice
ASG appearing
by an
for,
officer in charge
the
of a police station.
petitioner submits that despite the specific direction passed by the division bench to hand over the disposing of the aforesaid mandamus appeals, the accused Sikh Shahjahan forthwith to the CBI of the set date of the event date with further comma the state instrumentalities are taking one plea or another in order to frustrate the implementation and enforcement of the aforesaid expose themselves liable to be punished under the Contempt of Courts Act. It is further submitted that though a shelter is taken on the on the pretext of impediment on the part approaching of the Supreme Court in dealing with an application for contempt filed today, it is submitted that taking advantage of the statutory in the judgment, an order dated 5th March 2024, frustrate the very purpose and well encourage the accused to take the advantages provided under the statutory provisions. It is adversely submitted that Order 17, Rule 1 of the Supreme Court rules and orders that rules the filing of the special petition or an appeal put any fetter shall not in the execution of the decree or the order unless there is a specific or express order of stay passed. Either submits that the order needs to be implemented forthwith as the alleged contemners have liable to be dealt with under the Contempt of Courts Act. The learned ASG appearing for the CBI adopted the submissions made by the learned ASG appearing for the that the order dated 5/3/2024 was immediately communicated for its due implementation. But astonishingly, the response received through would indicate that, and otherwise, there has been a reluctance on their part to implement the order of order passed by this court. All such correspondences submits that would envisage that that intending to thwart the implementation of the order dated 5/3/2024, and therefore the court should not litigant who encourage such sanctity or respect to the judicial orders. Learned Advocate General after the passing submits of the order plus judgment dated 5/3/2024. The steps to file the special petition was taken and in fact filed at 1:39 a.m. It is further submitted that the matter was mentioned immediately after being communicated with the order dated 5/3/2024 before the Supreme Court was directed to mention the matter again after the filing of the special petition, which in fact was done.
I'm sorry for the interruption. There's a direct judgment of the Supreme Court, 3 judges, which says the bind. May I only point out one paragraph? I'm very, very sorry for the interjection.
Chief Justice of India during recess by the registry, and till date, until this time, the final decision has not been taken, or the appointed counsel, although in the said special petitions are weekly the directions that may be passed. He thus submits that the matter information may be postponed for a day so that his client may have a clarity in the. He thus submits that. No, full stop. Now, what you were saying, Mr. is
SCC 359.
please.
It's a 3-judge bench of the Supreme Court. Kindly
Without anything, does not tantamount to merger of an order of the High Court. There is no difficulty.
I'm not on that. I'm on a different point, which is decided in that judgment, my lords. I'm actually floored by my lord's knowledge, my lord. Kindly have a look at 14.4, my lords. Which appeal, which leave to appeal has been sought for, continues to be final, effective, and binding as between parties. It's binding.
The courts recognized by L. Chandra Kumar, the tribunal should have been slow to proceed against the party in
matter, whether the court can proceed with the contempt application granted by a higher forum in absence of any order of, or should stay away in passing any order to the higher forum simply by initiating a proceeding, by filing a special petition. An occasion to peruse the orders passed by the division bench, wherein on 5th March and startling facts have been revealed, and the role of the police administration have been more particularly vividly projected. Hide and seek methodology. The division bench observed probabilities to shield the accused, who is undoubtedly and highly influential political person, and have also the entire investigation is required to be done by the Central Bureau of Investigation. The custody of the said accused should also be handed over to the CBI on or before 4:30 p.m. It is no longer a sentence event date. Mere filing an appeal or the special petition before the higher forum does not tantamount to stay or put any fetter on the part of the court which passed such order to proceed and implement the same. The order dated 5/3/2024 was duly communicated by the CBI, but taking a plea that the special petition is in contemplation. The order, which was supposed to be enforced by 4:30 p.m. avoided, was shot to be, or in other words, its due implementation was intended to be postponed. The final verdict or an interim order directing a party to do a thing or abstain from doing certain thing, order is passed, it does not absolve such party to violate the aforesaid order or postponing the enforcement or implementation thereof in the gulf of taking steps to challenge the said order before the higher forum. Even Order 17, Rule 1 of the Supreme Court rules is explicit to the said extent, shall not prevent the execution of the decree or the order appealed against, forthcoming that the said order is liable to be that the enforceability of the said order is liable to be postponed, or in other words, the order to be kept in suspended animation until Supreme Court the disposal of the special petition rendered in case of Kamayuddin versus State of Kerala, wherein the apex court held that the efficacy of the judgment or its binding effect on the parties is not whittled down, or unless kept in abeyance, the leave to appeal is granted and an interim order is passed, cannot be construed as a suspension or a stay of the operation of the said order, as the party to such proceeding are bound by such order and cannot avoid the implementation thereof by the learned Advocate General to a subsequent judgment of Poddar versus Dhanina and others, reported in 2002, volume 1, for the proposition that the moment an appeal is filed before the higher court application, the court should. We have seen the facts, given facts, in order to find out the parity and the applicability of the ratio laid down in the aforesaid the report. The said order was assailed by the aggrieved person by filing a writ petition. But pending the writ petition, an application for contempt was taken out, alleging the violation of the said order at the the tribunal proceeded to dispose of the contempt application, convicting the director of a fine of rupees 2,000. Full stop. The said order was assailed. The apex court noticed and ultimately reached before that while passing the final order on a tribunal application, the tribunal did not fix the time. In the above backdrop of the fact, the court observed that the moment the challenge is made before the writ court, it should be slow in proceeding with the contempt application. The tribunal should be, but the apex court was conscious that taking advantage of the pendency or filing of an application, the order, and for such reason observed that although the court should be slow in proceeding with the contempt application, but it does not put any fetter on the part of the court in passing a direction for due implementation of the said order in the following, which is there. At any rate, the tribunal should have directed the appellant to implement the direction in absence of any stay order of the High Court. That's full line. The court, the order, cannot pass any order or rather to implement the manifestly clear that the observation of the apex court, so far as the final order to be passed on a contempt application, holding the alleged contemners are guilty of contempt in proceeding therewith, the court should be. We are concerned with the implementation of the direction passed in the order dated 5/3/2024. Considering the gravity of the gravity and the seriousness of the facts discerned in course of the disposal of the said proceeding, the division bench was of the view that the custody of the accused, namely Sheikh Shahjahan, should immediately be handed over to the CBI, and even proceeded to fix a time within which such custody is to be handed over of the direction. We do not find any fetter or impediment on our part in not directing the implementation of the said order pending the contempt application, despite the fact that a special petition. But the fact remains there is no interim order of stay of the operation of the said order passed as of this time. Since an opportunity is required to be given to deal with the allegations contained in the instant contempt application, we therefore direct the LS containers to file affidavit of opposition to the contempt application within 2 weeks from date. Reply, if any, shall be filed within a week thereafter. Stop. Next paragraph. To immediately implement the order, the LS containers are directed. Passed on 5/3/2024 by 4:30 today. When 4:30 today, full stop. Yes. Anything more?
Grateful.